But here's the key to this case, is precedent. We are all bound by the precedent of the appellate courts in this country, and they have consistently held that for a petitioner seeking injunctive relief, that they must show irreparable injury. This petitioner, now respondent, can't show anything but a little loss of money. And that didn't make it an irreparable injury. If he loses money and we're wrong, he can sue us. He has an adequate remedy at law, and he doesn't need to exercise this court's injunctive jurisdiction. Additionally, one of the elements that is essential to injunctive relief being issued is that the court must balance the harm to the respondent and the petitioner, whether respondent wants to admit it or not. While algae may eat a little bit of, or be eaten and generate a little bit of oxygen, 74% of the oxygen comes from plankton. So you have our very existence, and it can't be argued, whether it's in the record or not, that without oxygen, none of us are going to make it out of here alive, versus the almighty dollar. And that's what's in the scales of justice. And I urge you, your honors, to have the weight of that lady come down on the right side of this case and grant my client relief from this onerous injunction.
Before you sit down, sir, I recall something in your brief which we all have reviewed, written by Brad Sheppard, and it was excellent, dealing with the National Marine Fisheries Service's determination that sharks are a fundamental part of the ecosystem. What did you mean by that in that brief, sir?
What I mean by that, Your Honor, is that we cannot smell, taste, or see oxygen, but without it, we can't survive. And the whole chain of command, from plankton to small fish to big fish to sharks, keeps the oxygen flowing. And that's what I meant by that.
Thank you very much, Mr. Sheppard.
May it please the court.